I don't want to seal the entire file. It has to be, I have no problem with sealing and or redacting as long as it's in compliance with the rule. And normally I don't get involved, but I have to get involved in this because if the rule, I mean, if I don't make the appropriate findings, it's improper to seal. For example, state bar records, I get it, right?
Yeah.
Banking records, I get it, right?
Right.
And things like that. But does that stand for the proposition that the entire file is sealed? All right, we're moving on. Next up, page 12 of the calendar, and that's the estate of Wilfred Richard James Bosserman versus William Errico. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, and we'll move to the defense.
Yes, good morning, Your Honor. This is Garrett Chase, bar number 14498, on behalf of the plaintiffs.
And good morning, Your Honor. Matt Johnson on behalf of the defendants.
All right, and we have a feedback loop going on.
I've never had that happen. I'm not sure why it's doing that, Your Honor.
No, you're clear now. We're fine.
Okay.
This case just won't go away, huh?
Well,
We're trying.
All right. Anyway, this is plaintiff's motion to amend or modify findings of facts, conclusions of law. Is that correct?
That's correct, Your Honor.
All right, and we'll give the floor to the plaintiff.
Thank you, Your Honor. Again, Garrett Chase on behalf of the plaintiffs. Really, the motion just presents 2.5 issues. The first issue has to do with this court's language regarding the Rule 41 dismissal. And the second issue has to do with the sealing of the case. The half issue is just the issues with the submission and the request for attorney's fees. Just based on the fact that we really shouldn't be here, this court's direction was extremely clear, and the order that was ultimately submitted doesn't comply with either the direction from the court or Rule 3 involving sealing and redacting of records. So, looking at the language regarding dismissal, again, just to really briefly summarize, on pages 12 through 15 of the record, this court directed counsel to include 2 specific findings as underlying the decision to dismiss the case. And those were the deference to Mr. Errico's criminal proceedings and the plaintiff's disabilities. Neither of those were included in the order. And so all the motion seeks to do is include those findings specifically within the order as this court directed at the hearing. With regard to the sealing issues, the order just doesn't comply with SRCR 3. Specifically, that rule requires the documents to be specifically identified and specifically prohibits sealing an entire case. The findings listed in the order don't identify the documents, and this issue was also called out to Mr. Johnson's office. Language wasn't included in the final order identifying those documents, and instead the entire case was sealed. So,
Does that order say that?
yes, the order does just contain basically boilerplate language as to the standard for sealing documents, but there's no specific documents that are actually sealed. Mr. Johnson didn't file a motion identifying which documents to seal. He made the request orally at the hearing. And
I know what I said at the hearing. I mean, I don't have to remember with exact recollection regarding the particularities of this hearing, but I say the same thing in every hearing. It has to be, I have no problem with sealing and or redacting as long as it's in compliance with the rule. And I have to make specific findings. And this is one of those situations where you could agree as to what would be sealed, for example. But my question is always going to be this: look, I honor your stipulation, but you better make findings that are in compliance with the rule, because I'm required to do that.
Absolutely, Your Honor. And that's, we're not seeking to substantively modify the order. We just want those findings in.
Gotta have them, or I can't seal it. And it comes down to that. It would be in violation of the rule, because this is one of those areas as a trial judge, because normally I don't get involved, but I have to get involved in this because if the rule, if I don't make the appropriate findings, it's improper to seal.
Absolutely, Your Honor. And that was our issue with the order. And so that's the basis for the motion to amend, is to include your specific findings regarding dismissal, to include those specific findings regarding what is being sealed. And then, again, we shouldn't be here. Mr. Johnson was at the hearing. He heard the findings. We provided the transcript, which we ordered from the court so that he could see those. And he instead submitted the order ex parte, didn't give us an opportunity to submit a competing order, and then refused to amend the order to actually comport with the rule of this court's findings. So, unless the court has any other questions, that's sort of the gist of it. I know Mr. Johnson filed a SIR reply last Friday. We would object to that. Generally, we also, the case that's cited in there regarding this court's jurisdiction to hear a post-dismissal order is just incorrect.
Under Rule 60, you can always, right, within the appropriate time period. I get it. I do.
Unless the court has any other questions, we'll submit it on that.
I don't. Mr. Johnson, you have the floor, sir.
Yes, Your Honor. We submitted to Mr. Chase's office on April 22nd our version of the order. And the order does say, and I'll read you what the findings say regarding the sealing. This honorable court finds the following compelling privacy interests outweigh the public interest to access the court records in this case: attorney-client privilege information, work product, proprietary interests, protected confidentiality interests involving hundreds of clients protected under NRS 49.095, NRCP Rules 1.6, NRPC Rule 1.6, and fundamental rights guaranteed under Nevada law and the U.S. and Nevada Constitution, and additionally furthering the stipulated protective order entered pursuant to NRCP 26C. These compelling privacy interests outweigh the public interest in open court records in this case and justify and necessitate an order to seal the court records, including all discovery pursuant to Nevada Supreme Court Rule 3. So the findings are in there. And what we want sealed, Your Honor, and what I believe is sealed, is, and it says, the court records, including all discovery, including but not limited to State Bar of Nevada records and Nevada State Bank records, ordered sealed. Now, we submitted that on April 22nd.
And I have a question for you. And,
yes.
For example, State Bar records, I get it, right?
Yeah.
Banking records, I get it, right?
Right.
And things like that. But does that stand for the proposition that the entire file is sealed?
I don't think that the entire file needs to be sealed, but the discovery portion does. In fact, the discovery commissioner ordered them to be given back to us 5 years ago, which never happened.
I understand.
Yeah.
So we're on the same page as far as that's concerned.
Right.
Next question. What about the language that I set forth in the order? I'm sorry, I discussed in open court as to specifically what my findings would be.
As to what your findings would be,
Yeah.
we stated, let me look at the order again, Your Honor. We stated, in the order, we essentially referenced that the court having reviewed all the pending motions, the pleadings and papers, and the matter being heard by oral arguments. We enter the following findings and facts and conclusions of law, and we say, 1, the honorable court allowed the parties to enter into a stipulated stay to protect their respective rights. The stipulated stay expired. 2, the 5-year rule under NRCP 41E expired. 3, this honorable court entered a stipulated protective order on May 1st, 2018 under NRCP 26C. And then the findings that I just read to you about the compelling interest for the sealing. I did not have in there specifically, hey, on such and such a date, they filed this in 2013. We did agreed to stay it for a certain period of time. We kept it simple. I don't know that there's any findings that we missed, and what happened, Your Honor, I would take umbrage with the fact that they say, that we simply ignored everything and just submitted this ex parte. That's not what happened. We sent this to them on April 22nd. Mr. Garrett responded and said, hey, I'm going to order the transcript. There's some language I want to put in there. I said, okay. So on May 6th, I email him again. I say, hey, hi Garrett, we need to get this entered. Have you reviewed the transcript yet? Please let me know. Thank you. He responds that same day, May 6th, and says, Matt, thanks for the follow-up. I finally got the transcript. I'm working on my revisions. I'm in depositions all day today, but I will get you the revised order over the weekend. So I'm assuming by May 9th, which is the following Monday, I'm going to have revisions. Monday comes and goes. I don't get anything. I wait another 8 days. I wait till May 17th. I check with my staff. Have we got anything at all from them? No. By then, Your Honor, the time had passed under Local Rule 7.21. And I'm like, we got to submit this. The time's passed. We've got to get this thing submitted. So we submitted it on the 17th of May. Now, mind you, I sent it to him April 22nd. So it's about a month. He told me that he was going to get it over the weekend on May 6th, which would have been May 9th. I wait another 8 days to May 17th. I then submitted the order. On May 17th, we submitted the order. And then the court entered it like I think it was the 27th, Your Honor. So I wasn't hiding anything. I wasn't playing games. I was trying to get the order entered in accordance with Rule 7.21. And as far as the supplement we filed, there was some inference in their reply that the court maintains jurisdiction. And the case we cite, all we did is cite one case in the supplement, and that's Cox versus 8th Judicial District Court, found at 124 Nevada 918, 193 P. 3rd 530. And in that case, the court says, quote, because the 5-year deadline of NRCP 41E had passed, necessitating mandatory dismissal, which is the case here, the district court lost jurisdiction, and a subsequent judicial cell and a TRO to bar petitioners from challenging the judicial cell were void for lack of jurisdiction. So what happened in that case
But see,
in the
that's
Cox
different.
case?
I mean, I agree with the holding of the Nevada Supreme Court. That's
Right.
slightly different because all we're doing is this. We're looking at my order as it pertains to the granted dismissal in this case and whether it should contain additional language or not. I'm not holding jurisdiction as far as anything else that concerns this case or any other actions by the parties. This motion only focuses on the content of the order, which is a different matter, right?
And it's brought. First of all, it's brought too late. If they brought it, they should have brought it within 14 days after the order was after notice of entry, which they didn't do. And then they cite Rule 59, which doesn't have to do that because that's the case after a trial.
Right.
So I think even their request is brought too late, Your Honor. I mean, I'm not trying to be difficult here, but the order was entered. It was entered after twice conferring, saying, look, here you go. Where are you? And them telling me they're going to get it to me over the weekend. I wait another more than a week before submitting the order. By then, it's past the time that I'm supposed to submit the order under the rule. I'm just trying to follow the rules.
And you know what, Mr. Johnson, you've always tried to follow the rules. I'm not faulting you for that at all. And I don't mind saying this when I didn't even look at the rule that was relied upon. The first thing that jumped out was Rule 60A. Corrections based upon clerical mistakes, oversights, and omissions, focusing on orders. That's all. And it's not. I kind of look at it from this perspective because I was pretty clear that I wanted 2 points pointed out in the order, and I guess it comes down to whether the order clearly sets forth the points I base my decision on. And one, I just wanted to make sure that the order was clear that this matter was stayed for the purposes of concern regarding the defendant's Fifth Amendment constitutional rights, which we did, right? And I guess secondly, one of my decisions were made, part of it was based upon the mental disabilities of Mr. Bosserman, and nothing more, nothing less than that. And I said that should be entered into the prepared findings of facts and conclusions of law. And I said that in open court. And so the way I look at it from this perspective, and it's very straightforward, we can just amend the order and put this language in, just the statement from the court. Now, I understand potentially from an appellate purposes, yeah, you could look to the transcript, but sometimes transcripts are hard to find and hard to get a hold of down the road. But I felt it was just important because anytime I make a decision, I always want to set forth the reason why I make a decision on the record. That's
right. I understand that.
That's all. Yeah, nothing more. I'm not saying anybody did anything wrong at all. But I just want to make sure the record's clear. That's all. Okay. Anything else, though, Mr. Johnson?
Your Honor, I think that the order's fine the way that it is. I mean, it does say that we entered into a stipulated state to protect their respective rights. Did I say Fifth Amendment? No, but I said the parties entered into a stipulated state to protect their respective rights. I don't think I said anything about Bosserman's mental state. That's been made abundantly clear through the almost 10 years that this case has been pending. I mean, we've argued it. You've said you don't believe the statute of limitations can expire and he can file it again. We've argued, hey, he was represented by a guardian during that entire time, and the guardian should have, protected those rights. But regardless, I didn't put anything about Bosserman in there. That is true.
All right. Thank you, sir. Get the last word.
Thank you, Your Honor. I'll be brief, but I tend to agree with the direction I think the court's going. We're just asking for an amendment here. We did cite to Rule 60 and 59 in the motion.
Okay. Yeah, 68 jumped off the page. Right?
Absolutely. And to the extent that the reason we cited 59 as an alternative was to the extent that the court determined any of this was substantive, the Supreme Court said, and then it converts it to a 59 rule. But we agree it's Rule 60. That's actually, just as a point of clarification, the block quote in the SIR reply that Mr. Johnson filed, that's actually not a quote from the case. That's a summary of the case. That language specifically is not found in the case. But the Cox case does say it loses jurisdiction to decide the merits of the case, which this is not.
No.
So we would just ask that the order...
This is just clarification of my order.
Exactly.
Nothing more, nothing less. I'm going to grant the requested relief, sir, but I'm going to require you to amend the order and put that block quote that you're relying upon in the order so it's clear. And secondly, and I think we're kind of on the same page here as far as any issue as it pertains to sealing, I want to seal, I guess, the information we talked about. It would be from the State Bar and some of the discovery responses with particularity, but I don't want to seal the entire file.
But, Your Honor, all the bank records will be sealed, right?
Yeah, and bank records. That's what I want to seal. That's clearly in compliance with Rule 3, Supreme Court Rule 3. That's all I want to do. So this is what I want you gentlemen to do. I want you to take a look at it. I want you to run it by Mr. Johnson so we have more particularity as far as the Supreme Court Rule 3 issue is concerned, because I want to make findings that these would be privileged or trade secrets or privacy. You know what I mean? Whatever under the rule.
And those are in there already, I think, Your Honor, under paragraph 4 of the existing rules. Those findings are there.
But I don't think it would be the basis for sealing the entire litigation file, because it's not.
The State Bar record. So we're clear. The State Bar records, the bank records, and then the discovery.
All right. Yes.
Okay.
I don't think counsel has a problem with that, but you're right. I can't just seal the entire file. I can't do that.
And we don't have a problem with that, Your Honor. Thank you.
And he has no problem with that, Mr. Johnson. He'll run it by you.
Thank you, Your Honor.
All right. How about this? I'll set a status check in 30 days on the order.
Good idea.
Good idea, Mr. Johnson. And assuming both of you done this and signed off on it, let me know so I can vacate it. And that'll be September 8th of 2022 at 9:00 a.m. I know you'll get it done.
Thank you, Your Honor.
And gentlemen, I'm telling you this. I know what it's like to practice it. Fires come up. And you just run around from fire to fire.
That's it, Your Honor. Thank you.
I have a fire truck in my office, Your Honor.
I know. We all did, right? Thank God I don't steal fires anymore. Enjoy your day. All right. We're going to move on. Next, page 13.